Far from impeding negotiations in the achievement of a just and lasting two states, the Court's advisory opinion will further assist such efforts by making it possible for the parties to make progress on the sound basis of international law and international legitimacy. Mr. President, members of the Court, I now turn to more technical legal arguments of my submissions. The Court has heard various competing submissions this week with respect to question B of the request. But there can be little doubt as to the central importance of three matters. First, the role of the rules on the use of force in governing the unlawfulness of a given occupation itself. Second, the series of General Assembly and Security Council resolutions that have consistently and expressly called for Israel's withdrawal and referred to the inadmissibility of the acquisition of territory by war, which is a corollary of those rules. Third, the Court's advisory opinion on Namibia is a helpful reference point for the Court. Pakistan hopes to assist the Court by suggesting a slightly different way of looking at things, which leads to the conclusion that Israel's occupation is unlawful and unlawfulness must have consequences. In this respect, Pakistan considers that a useful touchstone for the Court is the general principle that no state can benefit from its own wrong. As Sir Gerald Fitzmaurice explained, and I quote, "The general principle is that states cannot profit from their own wrong, and similarly that rights and benefits cannot be derived from wrongdoing. This admits of no doubt. It is a wide general principle having many diverse applications under international law. Of course, these principles apply not merely as regards treaty obligations, but to general international law obligations also." End of quote. Notably, in the Wall case, Israel accepted that this principle is as relevant in advisory opinions as it is in contentious cases. The principle is particularly important, whereas here the wrongs at issue are of the most serious kind. Second, the principle in the context of applicable law. This principle is one of the underpinnings of the prohibition on the acquisition of territory either by force or through the denial of self-determination. The wrongs are obvious, and no benefit in terms of lawful possession or a legal entitlement to administer the territory could be derived. As to this case, if the Court agrees with Pakistan and with many other states that Israel is in continued breach of these fundamental primary obligations, it cannot allow Israel to benefit from its own ongoing wrongs by somehow avoiding the natural consequences that must follow under this law of state responsibility. These include the obligations of cessation and non-repetition, which require immediate and unconditional withdrawal, as well as the obligations of non-recognition and non-assistance for all other states. As to the applicable primary rules, it is customary international law and the charter that govern the illegality of a given occupation at any point in time. As a separate matter, international humanitarian law governs the conduct of an occupying power with respect to the occupied population. But if the occupation itself is unlawful, that carries legal consequences for Israel and for all states under the secondary rules of state responsibility. Those legal consequences are in no way displaced by separate consideration of the lawfulness under international humanitarian law of particular conduct in the course of the occupation, much less by hope for a negotiated solution. Any other approach would effectively permit Israel to benefit from its own wrongdoing. For the same reason, there is no scope for an argument that other states in their dealings with respect to Israel or the occupied Palestinian territory could somehow put to one side the question of the unlawfulness of the occupation itself. They could not, for example, elect instead to focus exclusively on the different questions of whether specific Israeli measures were absolutely necessary to meet legitimate security requirements, such that those measures are not unlawful under international humanitarian law. Third, the principle in the context of Namibia advisory opinion. Mr. President, members of the Court, any conclusion could not be reconciled with the Court's opinion on Namibia. There are certain clear parallels with the present case. The General Assembly had condemned South Africa's occupation of Namibia, characterizing this as an occupation that engaged the Geneva Conventions, and the Security Council had expressly called for South Africa's withdrawal. In a later resolution, after condemning South Africa's non-compliance with the earlier resolutions, the Security Council had also declared that, and I quote, "the continued presence of South African authorities in Namibia is illegal." End of quote.